Ms. Murray? Good morning, Ms. Murray.
Good morning, members of the court. Good morning, Your Honors. Crystal Murray, representing the defendant appellant Craig Powell in his direct appeal from his conviction for murder in the first degree based on extreme atrocity and cruelty. Now, the crux of the prosecution in this case was that Craig Powell murdered the deceased, Gerard Bannon, as Bannon lay in a recliner, and not as Powell contended, that he found Bannon's bloodied body on the basement floor and lifted it up much like you might a baby and put it in the recliner. And in order to prove that the defendant was lying and to put the defendant in the immediate vicinity of the blood-shedding event, the Commonwealth sought successfully to introduce expert opinion regarding blood stain pattern analysis. This was opposed vigorously by defense counsel at trial, both on the basis that the government had not shown the reliability of either the theory or the method used in this case, which was a so-called string method. And, well, here we are today with a Daubert issue, I believe a first impression before the court.
But not a first impression before other courts, correct?
That's true, Your Honor.
Well, the judge did a very careful analysis of this and came away with the conclusion that it met the Lanigan test. So,
well, what I would say, Your Honor, to that, my memory of the judge's comments were that she was quite persuaded. She was persuaded by two different things. First, she was persuaded by the criminalist contentions that the method was used, and therefore it was reliable. But one of the concerns I have, and I think what we have to look at...
I think that was the string method, right?
The string method.
Not the blood pattern analysis.
Well, let me just back up a little bit then. I think the aspect of the theory that we're concerned with in this case has to be what's known as source area determination. In other words, given a distribution of blood drops that could be described as spatter, and by, given their size and shape of the blood drops, and given their angles, their directionality, one can calculate the angle of impact, and from that calculate the original position. And then those calculations may be made by any one of apparently now a number of methods. That would be the string method in this case, but
Ms. Murray, let me ask you this: whatever the validity of the string method, and the droplets of blood, namely, if you're saying the real problem is the source area determination, his testimony is that the victim had already been killed, and he dragged him up and put him onto a recliner, correct?
I'm sorry, put him onto the recliner chair?
Yes. Correct? That's his...
That was the defendant's statement, yes, Your Honor.
It seemed to me that in that scenario, droplets are not likely, splatters are not likely to occur. In fact, won't occur. What you might get is sweeping marks or dragging marks or, what's the basis of saying that the real problem here is the source area determination? There were droplets, splatters,
I don't recall that there was any evidence of dragging. In fact, for all...
No, there wasn't, but I'm saying his theory.
Oh,
you're focusing on there's unquestionably, as I take it, evidence of droplets of blood, correct?
There is definite evidence of blood all over this basement room on both men.
Droplets of blood.
Right. I would say, though, in response to Your Honor's question, that first of all...
including on him.
On him.
That's my point.
On the defendant, there was testimony that the blood droplets on the defendant's clothing was spatter and not transfer blood? Well, I would say two things. First of all, as defense counsel showed, I don't think there was a piece of clothing of the defendant's that was examined that didn't show that there were reddish-brown stains that weren't, in fact, blood. So there was something else on that besides just blood. The other thing is that there was no evidence that even though you can say, well, in picking up the body like a baby, and that's how the defendant described it, I believe, putting one arm under his neck and pulling him up that way, and you almost get the sense that he was very close to the chair, but there was no evidence of exactly where that body was. In doing that, it strikes me that even though those blood drops could be considered transfer, that doesn't mean that they might not leave the image of spatter. In fact, the Commonwealth doesn't really dispute that, because the Commonwealth asked the jury to believe, to find, if not believe, that the transfer blood on the crumpled paper towel carried the image of the hammerhead. So what I'm saying here is the fact that what looked like spatter on the defendant's jacket could in fact have been the result of his picking up the body, and where the same image of small drops of blood just carried over onto his clothing. So I don't think it's that cut and dry. The jury was obviously very concerned that the government had not done enough in terms of really trying to identify the perpetrator here. Their question during deliberations was, why, with all this blood, did you perform DNA, the government perform DNA on just 2 drops? One on the sleeve of the defendant's jacket and one on the paper towel. So this was a definite concern.
Can I ask you a question, though, to go back to the beginning? You are challenging both the theory of source area determination, blood spatter analysis,
Yes.
and the specific methodology used in this case, which is string methodology.
Yes.
So both of those are being challenged, and that's appropriate.
Right, and if you look at the hearing on the transcript of the Doe-Bear hearing, I think you would have to agree that the government simply did not make its case of reliability.
On either one?
either one.
On source area determination or blood spatter analysis generally?
Right. In fact, the government didn't go near the method at all. It was up to the defense counsel to actually make a rather searching inquiry into the validity of the string method. But so I think what's very important here is that if we focus on source area determinations, very important in this case, because the government comes back and says, well, the bloodletting event, which in this case was the bludgeoning of Bannon's head, was in the general area above the chair. At the same time, and this I've gone into some detail in my brief, at the same time the government admits that that source area determination is only an approximation. It only gives the upper limit of the height, number one, and number two, there's no published standard deviation or range of reliability data as regards how far off it is. So I can, why couldn't that bloodletting source have been just to the side of the chair? Perhaps Bannon was standing up just by the side of the chair and the blows felled him. That would be consistent with the defendant's claim. So I think the problem here in terms of the general theory is that you have to say, well, what was the purpose of the analysis? Were we trying to decide whether the body was killed on this side of the room or that side of the room, or do we want a precise measurement of where, in this case, the head was located? Because I think that's where we get into problems. That's where Ms. Zilkowski can say, well, the string method is accepted because it's used. It works. Well, it works for what? I think there has to be limitations set on this theory at a minimum. But getting back
isn't that the appropriate realm of cross-examination at that point?
Well, that's what the judge seemed to think. But I would say, Your Honor, that if you look at both Lanigan and certainly at Patterson, there is a definite sense that it's too late for that to go to the jury. The jury can be too swayed by expert opinion in this area, that the determination of the soundness and the validity
Well,
of the application
if the science is sound and the methodology is sound, that doesn't mean that the methodology is being properly applied or will give you a reading which is close to within 6 inches. I mean, that does seem to be the subject of cross-examination, rather than testing whether both the science and the methodology are sound ways of determining source.
But here, Your Honor, it was never established how valid or how accurate.
Has any court ever questioned in its cases on blood pattern analysis the reliability of the so-called sling method?
The one out of jurisdiction, certainly not in Massachusetts.
No, I understand. We haven't looked at blood pattern analysis to my
The
knowledge.
one case I would be aware of in another jurisdiction, which my sister cited, no, did not say it was invalid, but they did find an instance where the government had not made its case in proving reliability.
Of blood pattern analysis.
Right.
But not focusing on the sling method.
Well, it definitely wasn't the string method that I
Correct.
recall, but I can't say if it concerned methodology or not. But going back to the presentment at the hearing, when it came to talking about error rates there was nothing in there in the testimony of Ms. Zilkowski about error rates for source area determinations. She simply says, well, the error rate is 0. Because it's based on principles of trigonometry and gravity. Well, I suggest that claim is specious. I mean, as I've said in my brief, I'm not arguing that the arc sine of the angle of impact can't be calculated as the arc sine of the width over the length of the blood drop. But the government itself acknowledges that the components, the very components that go into calculating the source area, namely the size, the shape, the directionality, and the angles of impact, are severely affected by the nature of the substrate that those drops are falling on. The government acknowledges this. So to claim a 0 error rate, I believe, just should not even be considered by the court. And along the same lines, Ms. Zilkowski elaborates that because of the nature of the substrate distorting the data, that the analyst then, or the tester, has to rely on her own subjective knowledge of how a particular type of substrate would enter into this, say, whether it was clothing or fabric or wallpaper or cement, whatever.
But that's not uncommon. It's certainly true in fingerprints, where the surface and all kinds of movement that may have occurred during the course of leaving the fingerprints will distort somewhat the print, and it's the examiner's expertise in evaluating those distortions and calculating for them is not uncommon.
No, I would agree with that, Your Honor, but I raise that point to say that then testing of the method may be a little bit difficult because it does have the
Ms.
subjective
Murray, I
element.
understand the import of your observation, but it seems to me, just to repeat what Justice Cordy said, that these are classic areas of cross-examination. Classic areas of cross-examination. They're not for me to disregard. I don't know whether a 0 error rate, I mean, you say to me it's specious. On what basis do I conclude it's specious if it hasn't been the subject of cross-examination?
My position, Your Honor, would be that it was up to the government to establish at that hearing that this is the published error rate for source area determination. That's what didn't happen at this hearing. We had a lot of hand-waving about it works or we like it, but there were no surveys. If you compare this to the Patterson case, where the government put in government surveys of, say, for example, 50 jurisdictions in 50 states in this country using latent fingerprint identification theory and the ACE-5 methodology. Or there were 50,000 latent fingerprints tested and 0 false positives. We have nothing like this here.
Yes, but not every not every theory and not every methodology is subject to the same level of detail. I can well understand, I mean, fingerprinting, which had been latent fingerprinting, which had been, pretty well accepted for a very long period of time. So when somebody's making, an attack on it, and a pretty directed, specific attack, the government responds in kind. But the attack was there. We don't shift it. We don't shift. The government puts in an expert. The expert says 0 error rate. Nobody challenges that. It's 0 error rate, unless it's challenged. I can't go out and look at the scientific papers that are not in evidence and say, oh, I actually see in Mr. Pizzola's paper of 1997 that the error rate was 0.004.
But I think what I'm objecting to is that the expert here, Ms. Zilkowski, said it's a 0 error rate because it's based on trigonometry.
Can I ask you this? You're probably much more knowledgeable, but I keep reading various materials talking about some forensic techniques that were accepted that have now been debunked.
Right.
Hair and out, metal contact of bullets has been, which was relied on, I guess, by the FBI for years, is now proven to be completely bogus or almost bogus. Are there other things like that? Hair analysis, teeth mark analysis, tool mark analysis? Do you know what the latest literature on all this is?
I'm sorry, Your Honor, I don't. I'm not much of a forensics person. But
No, but it is the obligation of when somebody proffers an expert either side, to cross-examine and to say, but aren't you aware of the fact that, this has been debunked in this journal, this journal, this journal, this journal, this journal?
Then perhaps I misunderstood Your Honor's questioning, because this did happen at the hearing. In
Right,
fact,
and
exactly that was the thrust of Ms. Robinson's questions.
In the Daubert hearing, the Daubert-Lanigan hearing
Right.
you're talking about.
Yeah, and she is saying, look, there's scientists now, and she submitted that paper, that excerpt from the paper by Dr. Carter. She's saying, look, there's people who are saying we can't live with the string method because of this parabolic
I understand,
arcing.
and then the judge has to make a determination, and then up on appeal, we review for what?
Abuse of discretion.
Correct.
And I'm saying that the judge's comments seem to be limited to the fact that she agreed that it was reliable because, quote unquote, it was used. I don't think her findings were detailed at all, as I recall. And the other was that she felt, as apparently this court does, that much of it could have been left for cross-examination. I did want to just mention the second part of the argument that concerns the fact that the expert at trial actually defined the single blood speck in the corners of the defendant's eyes as being spatter. And as I argue in my brief, that was tantamount. And keep in mind that there had been no forensics determination of the source of that blood speck. So at trial, that was tantamount to telling the jury that because it was called spatter, then it had to come from the deceased Bannon.
But that seems to me to be the perfect example of where cross-examination at trial is the tool to sort through that.
But my point was that it shouldn't have had to go that far, Your Honor, because there was no basis in the Ms. Zilkowski's trial testimony, or testimony at the voir dire, no basis in the trial testimony that a single speck would be spatter. Her definition of spatter is not rigorous, to be sure, but she goes very clear. She would leave no one with the impression that you could talk about spatter without talking about a blood distribution as a result of dispersal of blood from a force against a blood source. And so then to claim that these single specks were spatter, it may sound simple, but the jury, as I say, was concerned about lack of evidence about who was the perpetrator, and now we're being told that if it was spattered, well, then it had to be from Bannon, and here it is in the corner of the defendant's eyes. I think that was exceptionally prejudicial here. And finally, to talk about prejudice in general, let me just point out that this case had its problems for the government, very much so. First of all, we have the situation where when the police arrived, they find Bannon's body with his trousers unzipped and condoms at his feet. That had never been investigated, and that point was brought up to the jury. We then have the fact that the police themselves never were convinced, obviously from their actions, that the hammer was the murder weapon, that there really was no murder weapon presented at this trial. The police, after they had custody of the hammer, were across the street searching the area for what could have been the blunt object that killed Bannon. The fact, again, that there were reddish-brown stains on the defendant's clothing, many of them proved to be not blood. And maybe even, there was no skull matter or anything like that found on the defendant or his clothing or anything like that. And perhaps even for want of a better word, the defendant's ingenuousness, his announcement to the responding police officers that he had just gotten out of jail for threatening Jerry with a hammer.
Ms. Crowley, I'm sure you probably are not observing, but your red light is...
Yes, I am, and I will conclude, Your Honor. Just that was my conclusion. Okay. So I would ask for reversal, and I thank the court very much on behalf of Mr. Powell.
Thank you.
Thank you, Ms. Murray. Ms. Glennon?
Would you be so kind as to go through the Daubert-Lanigan hearing for us?
Certainly, Your Honor. First of all, good morning, Your Honors. My name, excuse me, my name is Lynn Brennan, and I represent the Commonwealth in this matter. As Chief Justice Marshall stated, the court is now considering whether or not Judge Botsford abused her discretion in finding that the Commonwealth had established its burden of showing that bloodstain pattern analysis and the string method were both reliable theories and methods. In this case, the Commonwealth sought to admit the testimony related to bloodstain pattern analysis and the string method to assist the jury in understanding and evaluating the significance of the blood evidence discovered at the site of the murder. The Commonwealth presented the testimony of senior criminalist from the Boston Police Crime Laboratory, Elizabeth Silkowski.
Could we? I know Justice Cordy has asked you to go through
Yes.
What happened, and we know about the examination and cross-examination and so on. But it seems to me that part of the thrust of the defendant's argument here is that Judge Botsford said she determined that the bloodstain pattern analysis admissible because she, quote, heard evidence that it is reliable and that it is used. I mean, yes. Was that sufficient?
Yes, her, Judge Botsford's factual findings relating to the hearing may not have been overly extensive, but she hit on exactly what the point was, that the Commonwealth presented evidence that bloodstain pattern analysis and the string method are used and that they are reliable. There was no evidence to the contrary presented.
She doesn't say that, and she doesn't say, I find that they're reliable. She just says, I've heard evidence that they're reliable.
I would suggest that she does not need, she's not required to specifically state for the record, I find that they are reliable. That is what she was saying. I've heard that it's used. She, in fact, did use the word reliable. I think it's reliable, and that was sufficient. There's no requirement that...
Did she say, I think it's reliable?
She did. I've heard, she did say, I think it's reliable. She said, I've heard evidence.
That it is.
Well, that's why I'm asking you to go back. And what was, in essence, the evidence of reliability?
Specifically, the evidence was that bloodstain pattern analysis is the basis of, Zilkowski named 3 professional associations, most significantly the International Association of Bloodstain Pattern Analysis Analysts, which is a 600-member, 20-year-old organization created to promote training, standardization, research, and publication of bloodstain pattern analysis. That courses and workshops are offered by those associations. Papers are published, articles are published, that both graduate undergraduate and graduate studies, or schools offer curricula in bloodstain pattern analysis, and in fact offer or award PhDs in the science of bloodstain pattern analysis. She specifically stated that it is generally accepted, Zielkowski did. Her claim was not specious. It was supported by the kind of information that I have just laid out or set forth to the court. Zielkowski also testified that she personally had lectured about bloodstain pattern analysis to students at local universities, to physicians at local hospitals, to investigators in police stations, to EMTs. All of these specific factors that Zielkowski touched upon indicate reliability. All of these meaning training programs, professional organizations, courses, seminars, specialized...
Are there standards in bloodstain pattern analysis, like there are in fingerprints, that examiners use and apply to specific situations?
Keeping to the record, Zielkowski...
did she testify about any standards that would apply to the application of this analysis?
She testified that the experiments conducted by Herbert McDonald, the leader in the field, had become standards in the field. She also testified that the International Association of Bloodstain Pattern Analysts, the purpose of that association was to set standards. She did not specifically testify what those standards were, but she did make reference to the fact that there are standards.
Didn't you also have forensic articles that were presented, or am I wrong on that?
Can you repeat that?
Forensic articles?
Did the Commonwealth present? Yes. Yes, Your Honor.
And then you presented the law of a number of other states that have recognized it?
The law of the states that have taken judicial notice of bloodstain pattern analysis because it is so firmly established as being a reliable science. Other jurisdictions that require little or no foundation to be offered.
And these articles, were there a lot of these articles that you presented? A lot of these?
The articles...
Studies articles?
I may be mistaken, Your Honor, but I don't believe that the actual articles themselves were presented.
She just testified about articles.
Was presented to Judge Botsford, and she did name the Canadian Journal of Forensic Sciences, the
One of the
or a few others.
one of the
She
things
was
that
asked on cross-examination, wasn't she, about some of the there was at least one scientific paper that seemed to throw some doubt, and she was questioned about that, right?
She was questioned about it, and significantly, the author of that article, I believe it's Aaron Carter, was the person who developed the competing method of source area, competing to the string method, a computerized system, the backtrack system. So he's the developer of that system, and significantly, the criticism that he offered was really focused more on a source area determination method called the tangent method, and not even the string method. He focused his criticism in the article that was submitted to the court, supposedly supporting the theory that the string method isn't reliable, attacked the tangent method much more so than the string method.
Now, in the fingerprint area, there are ways of at least testing the science, or some of the science, and certainly testing the proficiency of examiners by creating a series of fingerprints and asking a whole series of examiners to examine them and make some determinations about whether they're the same, whether they match. And then you can sort of give everybody the same stuff and then measure how many people get it right, how many people get it wrong. I suppose string analysis would be subject to the same kind of testing. You set up a room or a model, and then you send your examiners in, and how many where the source is, so the tester knows where the source is. How many people get it right? Has there been testing like that done of the string methodology?
There was, Your Honor, and there was extensive testimony at the voir dire hearing on that very issue. Zielkowski testified that she herself had participated in workshops, in training seminars, in her own lab, in controlled environmental studies for that very purpose. She would, be it with the string method or with bloodstain pattern analysis itself, would set up controlled experiments so that she knew where the source of the bloodshed or the bloodletting event was, and then use the method or the theory to test the scientific principles or the validity or reliability of the scientific principles underlying the theories. And she found in her experience, which I believe she characterized as experiments that she's done again and again and again in a controlled environment, in her experience, the rate of error was 1 to 2 centimeters. This is more specific to the string method, was 1 to 2 centimeters off.
Okay.
But that it would never mistake a person who was lying for a person who was sitting, for a person who was standing.
I take it that Crawford's essential attack is, in his words, that it's a kind of crude method. You know,
I didn't hear, did you say Carter in his?
a Carter. It's in his view, it's a kind of crude method. Well, that's okay.
Okay, and as I believe.
I mean, it may be that
that
modern technologies. I mean, you can take out a leveler, and that's kind of crude, or you can get a computer program that may make it a little tighter. But
You could, and both could be used. The fact that there's now a computerized method doesn't negate the reliability or the validity of the string method. And in fact, as cases have held, that there can be criticism of certain methods, and it doesn't mean that the method isn't reliable. There can be dissent among scientists in the field as to the propriety or the usefulness of certain methods.
Could I ask the question this way? If the issue was whether the victim's head had been moved 2 inches or 3 inches or 4 inches, maybe the sling method is too crude for that, correct?
Correct.
This victim's head was, if the victim wasn't in the recliner and was on the floor, is there something in the record that tells me how far the head is on the floor from where the head might have?
Not in terms of a measurement, but I understand
Is there
what
a
you're asking now,
photograph
Your
of the
Honor. And in
recliner?
I'm sorry.
Is there a photograph of
There
the?
was a photograph of the recliner. There was a photograph of.
And the victim's
Mr.
statement is, the defendant's statement is on the floor.
The defendant's statement is on the floor. I came in and I found Bannon lying dead on the floor. I picked him up, and the way he described it in his own words in his statement, the defendant, was that he held Bannon as if
Like a baby.
fire.
Yeah.
I thought I said a fireman. Could have been a baby. But in any event, I understand what you're asking now about if the precise location
Correct.
of the blood shedding event were
At issue.
then perhaps some issue could have been made about the arguably crude nature of the string method. Again, I would suggest that wouldn't necessarily mean that it's an inherently unreliable science. It would be the subject of cross-examination. But in any event, that wasn't the case here. There was testimony and there were photographs of the whole scene that there were no pools of blood anywhere in the room but for at the floor at the base of the recliner, which was consistent with the flow pattern. Heavy saturation of blood on the recliner right behind the head, brain matter on the recliner right by the head, blood flowing down the side of the recliner onto the floor, pool of blood right there. Other than that, and again, there was testimony and photographs, specks and spatters throughout the room. There was direct testimony by multiple investigators that there was no substantial pooling of blood anywhere else in the room. So in this case, the positioning of the head was not so significant.
And that, of course, doesn't establish that the defendant did it, but it's just inconsistent with the defendant's story.
Correct.
To a certain extent.
Correct.
But what about this notion of the witness testifying that the speck on his eyelid, I guess, was spatter? Was that subject to cross-examination, or?
That's certainly subject to cross-examination, and there were pictures of the defendant, and the defendant was in court throughout the trial, visible to the jury and to counsel, and they could have very easily raised as a proper subject of cross-examination the skin condition that the defendant had, and that he apparently suffered from eczema, and that it was perhaps arguably unclear as to what exactly, or from where that speck of blood came. That was clearly a proper issue or argument for cross-examination. The fact that Ziolkowski characterized the stain as spatter, and she didn't go into much detail at all. She just merely called it spatter when she testified about it. There was a reasonable basis for that opinion given the physical evidence in the whole room. There was spatter everywhere. There was spatter on the defendant's clothing. There was spatter on his boot. It wasn't unreasonable for her to opine that a small elliptical spot on his hand or a small elliptical spot, and that's how she characterized or defined spatter, as a spot small or stain small in size with an elliptical shape, that those spots were spatter. In any event, the testimony was cumulative of spatter that was all over the defendant's clothing and footwear, and the spatter on the hammer or character.
But I take it there were only a couple of, maybe I'm wrong about this, a couple of spots that were actually, well, I guess there were a lot of spots tested to determine whether it was blood or not, right? But only a couple of DNA tests to determine whose blood?
Correct, two.
And which were the two pieces that were tested for DNA
Sample
purposes?
from defendant's suede jacket.
Right.
And a sample from the paper towel that was recovered from inside the pocket of that jacket. The stains on the face were too small.
But they did test positive for blood.
I'm sorry?
They did test positive for blood, they just couldn't do it. That's all right.
I need to look at my piece of
That's
paper
okay.
to tell you that. They may have, I believe some weekly positive.
Were they tested?
DNA tested?
No.
Oh, for blood? I
Yeah,
have to
on
ask.
his face? I thought there were photographs taken.
Oh, that's right. There were two, that's absolutely right. They were swabbed, they were collected, and the sample was too small for testing. That's right.
So we don't even know if they were blood.
Don't know if they were blood, but again, looking at the evidence as a whole, the blood evidence as a whole, it was not unreasonable for her to characterize it as spatter, and even if it was an error and she should not have characterized it as such, it could not have been unduly prejudicial to the defendant given the amount of spatter covering his clothing and his footwear. As to the defendant's argument that the defendant was...
Is there a challenge to the fact that they're blood or a challenge to the fact that they are spatter?
I don't know.
Well, maybe I'm asking a stupid question. I thought the defendant's challenge was that it was spatter, not that the defendant's challenge was that it wasn't blood.
That's correct. There's been no issue raised, no challenge to whether or not...
Whether or not it was blood, correct? It's whether or not it was...
Only that
whether
it
it was spatter.
referred to as spatter.
Okay.
Correct. Even if there was error on Judge Botsford's part by finding that the theory of blood stain pattern analysis and the string method employed was reliable, which I would suggest clearly it was not an error. There was no abuse of discretion in her making that finding. If there were error, it would have been harmless given the overwhelming evidence of the defendant's guilt. Counsel suggests that this was the crux of the Commonwealth's case. It was not at all the crux. It certainly was a significant factor in proving the guilt of the defendant. However, the jury also heard strong evidence of the defendant's motive. He had been employed as a handyman in this house. He had been allowed to live in the basement. He was fired from his job as a handyman. He was told to move out of the basement. Bannon got the job as the handyman. Bannon moved into the basement. Bannon started wearing the defendant's clothes. Bannon took the defendant's tools and wouldn't return them. Just 1 month prior to the murder, the two had gotten into some sort of an argument again over tools, and the defendant assaulted and ultimately admitted before the Dorchester District Court to having assaulted Bannon with a hammer. So there was clear evidence of the defendant's motive. There was also clear and strong evidence of the defendant's state of mind in the hours leading up to the murder. The probation officer who did the probation intake for the defendant on the day he was released from custody from the Dorchester District Court, which incidentally was the afternoon just prior to the early morning murder of Bannon, testified that the defendant seemed very dissatisfied with the outcome of his case and that during the intake process he repeatedly talked about getting his tools back. On the same day, the defendant told a longtime friend that the victim in the assault with a dangerous weapon case had lied to the police, that the defendant's arrest was unjustified, and that he planned to go back to the house to remove a lock and to go a lock from the basement door and to go into the basement and retrieve his tools. Significantly, the defendant had at that time obtained another contracting job such that there was presumably a strong incentive for him to retrieve those tools. That same evening, he went to a pizza shop where a tenant at the house lived. He asked the tenant to help him get his job as a handyman back. He was heard saying, "The white guy got my job." During the late nighttime hours that just led into the early morning murder, the defendant went to various tenants' apartments, asked for their help in getting into the basement so that he could retrieve his tools. He sounded drunk to the tenants. They all refused his requests, and significantly, one of the tenants testified that the defendant returned to his apartment, asked him to hold his tools, the defendant's tools, till the next day, and stated that Bannon was dead. The motive, the state of mind, coupled with the physical evidence that the jury had to consider, that being the defendant's inconsistent statement in conjunction with the physical blood evidence at the scene, all were the basis of overwhelming evidence of the defendant's guilt. And very quickly, I'll just get to the grand jury petition for blood order.
We'll see how fast you can talk.
I've got 20 seconds. I can go very fast. As required, the information contained in the petition and the accompanying affidavit set forth a reasonable basis for the grand jury's belief that a sample of the defendant's blood would significantly aid in their investigation. They had set forth, the foreperson had set forth in the petition certain facts that the grand jury had heard, which, coupled with the information contained in the accompanying affidavit, provided that reasonable basis. And I'll just cite to Commonwealth versus Henry Juan Williams for all the reasons why there was no error with the judge allowing that motion, and also just add that Judge Walker did in fact make findings of fact, despite the defendant's contention to the contrary that there were no findings. He did make findings relative to there being a reasonable basis for the request. And if there are no questions, I will brief and ask the court to please affirm the defendant's conviction for murder in the first degree.
Thank you, Ms. Brennan.